Steve Cope, here. Richard Shea, here. Well, that's 18 minutes, but you only get 15.
I know. I hope I won't need all of it, but I do have a lot for you. My name is Susan Moffat. I'm a former legislative research, and I want to be clear up front that I am not the kind of ruthless, laser-focused pitbull contract attorney that you need to review these documents, and I say that in the most loving possible way. But I am an experienced legal researcher and a policy analyst, and I can tell you that there are enough dangerous clauses and ambiguous language in these contracts still today that I believe it is your duty to the Austin taxpayers to ensure that all of these documents are thoroughly vetted by highly skilled, specialized outside counsel with experience in both contracts and the constitutional issues of delegation that were discussed earlier. I truly appreciate the work City Law has done on this, and I in no way mean this to demean them, but they have full-time jobs. This is a big, scary animal with a lot of moving parts, and we're in it for the long haul, so I implore you to just pick up the phone and get the legal counsel you need on this. As you know, the contracts were only posted to the city website late Monday, less than 48 hours before this meeting, so this is a very hasty overview. I'm going to hit the three biggest issues first, and then I'm just going to plow on the details until I run out of time. And again, this is not about whether you love F1 or you don't. It's really about making sure the city and the taxpayers are fully protected under the legal agreements you're considering. So first, none of the contracts currently contain any enforceable financial assurances for the city to ensure that F1, which for these purposes is CELOC, the Local Organizing Committee, to ensure their commitment to cover the city's tax increment for the entire length of the contract. All the clauses that are in these contracts requiring financial assurances only apply to the state. They do not apply to the city. There is no requirement for a performance bond or collateral or any other kind of financial instrument to protect the city should CELOC fail to pay the local tax increment in any of the next 10 years. CELOC is a nonprofit that was formed 3 weeks ago by the applicant's attorney. It has no assets. So the city does not have viable recourse if CELOC defaults on the payments unless you get a clause in there. The language is already in the contract that provides financial protection for the state, and you can find it on page 4 in the CELOC agreement, section 19F, which says, quote, provide and fund a performance bond or other financial performance assurance in a form and with an institution acceptable to the state, ensuring the state's increment funding. So these contracts have to have that same language that provides and funds a performance bond or some other viable financial instrument that ensure our local increment in the event that CELOC fails to make a payment at any point during the run of the contract. So that's big. And that's actually something that's pretty easy to understand and should be pretty easy to fix. Second is the state, and this was touched on, is granting in these documents a sweeping legal authority to CELOC, which is an entity created by F1 promoters and agents without any voting representation at all in the city on that body. And under the contracts as they're currently drafted, you are giving CELOC full authority to negotiate with the site selection organization, which is F1, without any review or prior approval by you, the city council. CELOC will be authorized to act in the city's behalf in our name, yet as a creation of the F1 promoters, its interests are not necessarily aligned with the city's interests. And the only city representation on CELOC right now in the drafts you have consists of one non-voting member. Now, whether that creates an unconstitutional delegation of legal authority that somebody could sue over is open to debate, like a lot of things. But even if it's found to be legal, it's really just not very smart. If this were your own money, you would not hand all the authority over to a bunch of people you don't even know that you have no control over. This doesn't make sense, and it doesn't protect people. So that's two. The third big issue is that I do not believe that these contracts can negate the comptroller's statutory duty to protect the beneficiary of the Major Events Trust Fund, which is F1, not the city. You can't contract to ignore state law. In fact, if you could, every tax-paying AISD parent would be contracting directly with AISD so that we wouldn't have to follow plainly established as the trustee of the fund, and F1, which in the statute is known as the site selection organization, is the beneficiary of that fund. It is the comptroller's statutory duty as the trustee of that fund to protect F1 as the beneficiary. The city cannot, by contract, take away either the statutory rights of the beneficiary or the statutory duties of the comptroller. And in fact, the notorious Section 15 is still in the Major Events Trust Fund contract, which says that if the contracts are terminated for cause, the fund still exists, as does its purpose. So that is not wiped out, and that doesn't wipe out the comptroller's statutory obligations under that law. So I want to just walk you through what this would look like on the ground. Let's say at some point down the road, CELOC decides it wants to stop paying the state its $4 million a year that they said they would. And this is totally understandable because I can't figure out why anybody would want to give $4 million to the same people who took away our congressional district. But let's say CELOC gets on board with that and they don't want to see it go either. So they stop paying for whatever reason. Maybe they run out of money, maybe they just don't care anymore. We, the city, can't get any money from CELOC because under the current contract, CELOC is a nonprofit with no assets and the contracts don't include a performance bond to protect us. So when the CELOC doesn't pay, that automatically terminates our contract with them. And in theory, there is some language in one of these contracts, maybe more, that says it can terminate the contract with the state. But the problem is the fund has already been established. And it's governed under state law, not by a contract. So this is where the comptroller has the statutory duty to the beneficiary, which is F1. And she's already promised them $25 million a year. In fact, she promised them that in a letter she sent back in 2008 without talking to any of us about it. And she could possibly do it in later contracts because we're about to give all our negotiating and contractual authority over to CELOC, so I don't know what they're going to come up with. But anyway, under the law, she still has to protect their interests. They are the beneficiary. She is the trustee. So to give F1 that $25 million a year she promised them as the beneficiary, the comptroller has to still come up with our $4 million local increment. And under the statute, she still has the right, and in fact, she has the statutory duty to continue scraping the $4 million or whatever number it's up to by then out of Austin's tax revenues, even if the contract is terminated. And because the comptroller also, under the law, has the sole authority to determine the amount of our increment, and I want to make sure we all understand there is no way that the comptroller tracks this. This is all based on the economic impact study that CELOC, the creation of F1, will be giving to the comptroller to bless. So she can come up with any number that she feels like blessing based on the economic study that was done by the creation of the people who stand to benefit from it. I just think that is scary and irresponsible. And remember, we have no financial assurances under the current contract. So in view of the significance of these big potential legal problems, and these are just the biggest three, I do really believe that your responsibility to the taxpayers of Austin obligates you to have these contracts thoroughly reviewed by an independent, highly specialized outside counsel before you vote to approve them, and I strongly encourage you to do so again. Under state law, you have until next March, to take action on these contracts, and the comptroller's authority to write a check pursuant to these contracts is now subject to a lawsuit, so it's quite possible that the applicant's manufactured July 31st deadline won't even stand up in court. I also want to point out that as of yesterday, neither of the named site selection organizations identified in the governing statute that she'd be writing a check to under these contracts. Neither of those bodies were authorized to do business in the state of Texas, according to the Secretary of State's office. The race date hasn't been certified by F1's governing body. The county either has or to issue a stop work order on the project because FEMA hasn't issued the required blessing in the time period to let them build on the floodplain. And then F1's own future, if you read the New York Times sports section this week, is something of a question mark. The teams may defect. We don't really know what F1's going to look like at this time next year. So it's not like every other element in this deal is solid and this is the last piece that we just need to click into place. In fact, nothing in this deal is solid at the moment, and I think it would behoove you to take the time you need to get all this vetted by my imaginary pit bull, ruthless attorney, and somebody who has vast experience dealing with the statutory obligations in the context of these complex legal instruments. And finally, I think it's also important to understand that Circuit of the Americas, which owns the track and is building the facility out there in Elroy, they're not actually eligible at this moment to receive any of the money we're talking about today. I mean, CELOC can change that later on once we give them the authority to do what they want. But right now, this money, our money, the state's money, that's not going to Circuit of Americas. So Redmond Combs and his other facility investors don't actually have a dog in today's fight. And they'll either keep building a proposed facility, which the supporters have said will be busy year-round, even without F1, and I assume that will be a going venture. And if not, they will have a fine piece of property that's just going to increase in value as time goes by. But either way, it's not our business as the city to shore up a gamble that was made by skilled businessmen and consenting adults with their eyes wide open. So the facility is a whole separate issue than the money for the sanction fee, and that's what you have the power to talk about today. So again, no rush under the governing law. You know, I hope you won't be bullied into a premature decision until you have anything vetted. Now, the time I have left, there's a lot of other stuff, and I'm just going to go through as fast as I can and see how far I get. Well, first of all, there's no financial disclosure for the CELOC members of the contract. We really need to know if we're giving them all our power if they have financial conflicts of interest. So that needs to be in there. The provision that allows the city to terminate its interlocal agreement with the comptroller is contained in the recital section of the CELOC contract, not the agreement section, and this presents two problems. Recitals may not be enforceable. Generally, enforceable obligations and rights of parties will be in the operative body of the agreement, and the recitals are really just statements explaining the reasons for the agreement and the existence of certain facts, so it's dangerous that they're there. And even if the clause were enforceable, once again, it can't negate state law. So, next, item 9 in the recital section of the CELOC agreement doesn't require the expenditure of city funds, but this is very ambiguous language. That is not the same as saying withholding tax revenues. I mean, expenditure of city funds implies funds you already have that you'd be taking out of your general fund and giving to the fund. And the ambiguity of that language scares me, but again, even if it got cleared up, it's still in the recital section. So there's no, real way to know if it's enforceable. Next, CELOC has the sole authority to produce the economic impact studies for the comptroller, and these contracts right now do not provide for an audit or a legal review by the city. And again, I think it's just dangerous to give power to the body that is created by the ultimate beneficiary to decide what the economic impact statements are going to say. Okay, next, in the CELOC agreement, section 19D provides, quote, the city may ratify any non-compliant or untimely performance by CELOC, and upon such ratification, the complaint or performance will be considered and deemed compliant, performed, cured, timely, unquote. This is basically a get-out-of-jail-free card. CELOC can do whatever it wants, and somebody gets to bless it and say, well, even though they broke it, we're going to say it's okay. My concern here is city is not defined, and we need to know whether that is the city council that has the power to do that, whether it's the city manager, whether it's an assistant city manager, or whether it's just a staff member. We gotta know that. Okay, next, in the CELOC agreement, sections 22 and 23 list the entities eligible for disbursements from the fund, but the city's not on any of these lists. If this contract's really gonna run 10 years, automatically renewing, which I don't think it should, we don't know what the city's future expenses, and I think we need to at least be on these lists with the city as a placeholder to be eligible for future reimbursements. Okay, next, I really want to thank, with everybody else, Councilmember Riley for all of the work he's done on the sustainability measures, and Councilmember Martinez for the MWBE measures, but they really don't have the teeth they need to have right now. They need to be enforceable. If CODA fails to meet any of the conditions, all we get to do is terminate our contract with CELOC, which doesn't get us anywhere because the statute's still in effect. So I'm concerned about the enforceability of those provisions, even though I very much appreciate the work that went into them. Next, none of the performance measures are tied to actual event performance. So if F1, the drivers all go away and make their own event and F1 doesn't get anything, we are still on the hook even if it doesn't generate any additional taxes. Is that me? Am I done?
15 minutes, yes.
I got it.
Thank you.
There you go, Kate.